So I must say, to that extent, he mentored me.
We've seen that in your current practice, you rarely take on criminal matters. Would I be right to say, or maybe you can tell us, whether this outcome or this case is what shifted your mindset from doing criminal matters, or did you pursue criminal matters after this?
No, my shift from criminal cases, I still do a few. And indeed, anytime a criminal brief comes through the office and it's a matter which, as a partnership, we decide that we ought to take, oftentimes it will be allocated to me because of my past experience. But what made me migrate from the criminal bar practice was, I do recall a case, very sad case, where the court, the registrar of the High Court, allocated to me a pro bono brief. You know, all murder cases, there's the pauper briefs, which in our days, and I think it's still there today, there's a list of lawyers who submit their names for pauper briefs. And I was one, my name happened to be in that list. So I was given a pauper brief where the accused person assigned to me had been charged with the offense of murder. And as the law required, any person charged with murder had to be represented. And where they couldn't afford representation, the government would secure a lawyer in what was referred to as a pauper brief. In this particular case, the strength of our case, with hindsight, lay on the weakness of the prosecution case. And the weakness of the prosecution case, as I later on reflected, seemed to have been deliberate. We went through the trial, and my client was acquitted at the end of the trial. And at that time, as a young lawyer with fire burning in my belly, I thought I was a great lawyer. I had secured an acquittal. You know, we were all looking at lawyers like Johnnie Cochran on the O.J. Simpson case, and we all wanted to be like him, getting people charged on capital offense acquitted. And as I left court, there was a lady who was standing outside the courthouse. She had left just before me. I was still celebrating my victory with my client. So when I walked out, I found this lady. She had one child who was breastfeeding. The child was, of course, probably 1 year or so, and probably was breastfeeding because sometimes the poverty that some of these people experience is such that the only food you can give a child is breast milk, even if the child has passed the age of breastfeeding. So this child was tugging at the lady's breast while she's breastfeeding, and another one was holding on to a skirt, probably a 3-4-year-old child. And the lady looked at me with tears in her eyes, and she told me, I have let the person who killed her husband go free. I mean, it was a very stinging statement. And I thought about it, and I looked at her, and I told her I didn't let the accused person free. It's the court who set that person free because the prosecution was unable to prove that the person had killed your husband. And I walked away, but it disturbed me. For many years, I kept on wondering, would I have done things differently? But later, I realized that in a functioning criminal justice system, all parties must do their role so that the court can be able to come to a just and fair decision. In this particular case, and I can say this without fear of contradiction, the prosecution, either deliberately or out of negligence, or just that they didn't care, fell short of what would be expected in a prosecution. So my client was not acquitted because he was innocent. He was acquitted because the prosecution failed to prove their case beyond reasonable doubt.
Such a contrast. In one case, your client, who's actually innocent, was at the first instance convicted, and now you take on another case, a very challenging case, a murder brief, and you're able to get your client acquitted. And again, as you say, because of the lack, or rather the deficiency in the prosecution's case. I think we need you to again walk us through. Now you're from the young lawyer. Tell us a bit more about the history that got us to where we are now, and any other significant cases that you can remember through that history, from now the young Chacha to the senior partner at Odera Company, from the young Chacha who joined in 1990. Tell us your steps, because maybe there's a lot of people out there who want to know, how does one get from here to the senior partner in a firm, and to being given or being conferred the role of senior counsel. So there must be a way that or steps that you took to get where you are right now.
Yes, it was a journey. I mean, I don't know whether it's deliberate or whether just that's how things happen. I was the youngest lawyer in the office, or the newly admitted lawyer. And my office was situated at the far east end of the firm, what we these days refer to as the East Wing. And of course, the partners were up at the West Wing at the other end. And as a young lawyer, we were always trying, as I told you earlier, minimum effort with maximum returns. That's what we were always aiming at. Coming in just before 8 a.m. and leaving, if you could, without being caught, before 5. And always trying to put as little work as possible, but expect maximum compensation for it. But Mr. George O'Hara placed me on a very short leash. At one point, I realized every time he had wanted to see me for a meeting, he'd always fix a meeting at 5:30, 6 o'clock in the evening, just to ensure that I hung out later than 5 o'clock. And sometimes his meetings would also be at about 7 in the morning. And there were times, I mean, we didn't have mobile phones. He'd call me at night on my landline in the house and tell me he wants me in the office tomorrow at 7:15. We have a meeting. And as a result of all that, I first developed that routine, which I keep to date, of coming in very early. And I used to leave very late. These days I try controlling the hours. And as I said, I was kept on a short leash. And Mr. Raro also involved me in many of his cases, which meant that I had to be on top of things. I had to know the facts. I had to know the status of each case. I had to be the person fixing meetings with clients. I had to be the person ensuring that papers were filed. So I must say, to that extent, he mentored me. And I was able to not only address the question of work ethic, but also quality control and client care. So it has been a journey. This is way back 1990 to now. And within the journey, there was also my late partner, Mr. John Ugo. John Ugo was a workhorse. He was just 2 years older than me. But the amount of work that he packed during his lifetime, especially in practice, was much more than many lawyers would pack, even if they lived the full 70 years. John died at 47 years. But what he was able to achieve was what one would say mind-blowing. And with a team, in disputes team, George Oraro on one side, John Owugo right behind him, these were people who mentored me and who continue mentoring me. And it hasn't been, moving from the east wing to the west wing. It's not like instant coffee. For you to mature and get to that level which you can handle the responsibility that comes with the office of senior partner, you needed to have matured over a period of time. There are hits, there are misses, there are mistakes, there are achievements, there are all those kind of things. And I learned quite early that from your achievements, the great things that you do, always take them as an achievement which you need to emulate and replicate as you go forward. But where there are mistakes, those are also lessons of how not to do things. So when sometimes somebody reminds me that I've been 38 years in practice, I get shocked because I've been so busy this 38 years that time has just slipped by. And I must say that with a supporting team in the office and also a supporting team back at home, I have my lovely wife who keeps on encouraging me, even days when I come back home feeling really low. She always reminds me of the book of Lamentations, which says, my mercies are renewed every morning. So she will tell me, well, today may not have been a great day, but tomorrow is another day. I have my children, and we do have two of our own, but we are parents to many other children who we take in and who we stand in as parents. Every time I look at these children, I always consider myself not just as a parent, but as a textbook for them to learn from. So I must always ask myself, what would I like them to learn and what would I like them to turn out to be? And one of the things which I always say, one must have values. Humility being one of them, a sense of purpose, a sense of striving for excellence, integrity, and the other values which we really must be able to embody. A person who coasts through life without values or without a vision is merely like a rudderless ship up in the open sea. So to answer your question, the journey from 1990, from the east wing of the office, that beady young man, always trying to apply minimum for maximum rewards, to the person up at the senior partner's office in the West Wing, has not been something which fell upon me merely as a result of longevity. It has been as a result of a journey in which my hands have been held by many people, and not just by my seniors, even the support team I've worked with, whether they're my fellow lawyers, both who may be my seniors or those who came after me, the support staff, and as I always say, even that person who ensures that the environment we are working in is clean, that person who nourishes us by providing the teas and other refreshments in the office, that person who ensures that what we have prepared in the office finds its way to court and is served upon the other people. It is one large team. And that reminds me of one time I was with the late Dr. Richard Leakey, who was an old boy of my school. And over lunch, I asked him about his tenure as head of public service. And I called him boss. And he told me, no, Chacha, I was not boss. We were a team, and I merely occupied one of the positions in the team. So even at Oraro and Company, it's what we always refer to as OCO, I always consider myself that I'm merely a team member of a larger team, and we must all work together to be able to achieve our objectives.
Thank you. We can see if someone is hearing this journey, it seems one that is quite intense, rigorous, where you need to put in a lot of hours, a lot of work, have a lot of discipline. What advice would you give, maybe on how you were able to manage that work-life balance, to be able to be there for the office, but at the same time be there for your family, be there for that life out of the office? And what advice would you be able to give that young lawyer who's trying to follow a similar path on how to manage that work-life balance? And have there been any regrets also in that regard?
It's an interesting question, and always one which is always on the fore of various discussions of professionals. But I always look at it this way. In life, we have expectations. And to meet these expectations, certain things must be done, or certain sacrifices must be made. So the challenge is the balance one needs to, in making these sacrifices and working. How do you ensure that you're able to work, get compensated for it, so that you can meet the expectations, both your personal ones and that of your family? Because one can decide that I can give my all to the family. That would be an ideal situation. But by sitting at home and looking at one another, you will not be able to get the resources that you will require to bring up this family. And also, we always look, even as we talk about work-life balance, we forget that time spent in the office or time that you spend working is also a learning curve for your children, in the sense that they start appreciating that life requires hard work. But having said that, I'm also the view that you shouldn't be extreme in it. By all means, work hard, put in the hours, but also create time for you with your spouse and your children, and also for your social life. So we need to have a balance, and it's difficult to prescribe. I may not be the ideal person to tell you what it was. Do I have regrets? I tried my best. And I believe it's a question which my wife and children would be better to answer. Was I there for them? I tried. I was not always there for them, but as much as I could, I did. So it's a matter which maybe one day, when I've kept my appointment with my Creator, the person who will read my eulogy will tell you people in my absence whether I did well or I did not. I do not want to be a judge in my own cause.
You've been highly ranked not only as a disputes lawyer in general, but also in the employment law space as one of the top or highly ranked employment lawyers in Kenya. Maybe could you take us through that journey? How did you get into that space? And what lessons have you learned from them? Yes, from that space and the cases that you've been handling.
Yes, I've been fortunate to have been around for a period which covers the old employment legal regime under the then Employment Act, Chapter 226 of the laws of Kenya, to the tectonic shift which was occasioned by the various enactments which took place in 2007, where various pieces of legislation were enacted whose effect was to shift from the old employment legal regime, which was majorly based purely on contract, to the new regime, which emphasis is not just made purely on contract, but on fairness, procedural fairness, and justification. You will recall that under the old legal regime, just as an employee would give notice and resign without appending any reason, similarly, an employer could do likewise. An employer was entitled to terminate an employee's employment without notice, without appending any reason. And if it was found that he or she had wrongfully terminated, the only payment which would be available is the payment in respect of the notice period, such that if there was a provision that termination is by issuance of 1 month notice, that's what the employee would be paid. 3 months notice, that's what the employee would be paid. But fast forward in 2007, the employer was required to have valid reasons to terminate the employment of an employee. And even before arriving at that decision, there had to be a process, a fair hearing, which was then captured also in 2010 in our 2010 Constitution, where there was a right to a fair hearing and a fair administrative action, which means that unlike the old days when I didn't have to hear you, I'm just not happy with you, and I tell you our journey terminates here, today there is a process. A notice to show cause must be issued. A hearing must take place. A decision must be made. And that decision is still open to an appeal to another level. So it's no longer as it was then. And at the time I joined practice, we had the industrial court. And the industrial court, when I think about it, it was merely, it was very much a court of mediation. And many people deemed it to be a court sympathetic with the unions, unionizable employees, and employers never wanted cases there. In fact, they would always argue you don't have jurisdiction. This is a purely contractual matter. It must be heard by other courts. But come 2007, we had the Employment and Labor Relations Court set up. I think it was 2011, I believe. 2011, because it was after the Constitution, which set up those courts and made the assigned judges whose status was similar to a high court judge. In the old industrial court, the president was the late Justice Said Coker. And for a long time, he was there alone before it was expanded. And I recall an interesting case where I was acting for some airline. And the airline had employed this lady. And at the point of employment, the lady was promised in her letter of appointment that upon retirement, she will be entitled to a pension. She served her time, And when he came to retirement, she discovered there was no pension scheme. So she went to the industrial court and sued the employer. The employer instructed me. We argued that point, and the court agreed with the lady, told the employer that the onus of setting up a pension scheme was the employer's. Since the employer had not set up the pension scheme, but had promised the employee in the contract that there'll be a pension, the employer would have to pay the pension. And the court went ahead and even determined how much should be paid on a monthly basis. And the order was my client would pay the monies in respect of pension until the lady died. When I told my client what the court had ruled, and the industrial court, there was no appeal from their decisions. I think that was section 17 then of the Trade Disputes Act. I'm not sure of the section, but there was no appeal. So I told my client, well, you just have to look for money every month and pay this lady. And my client went into deep thought. Holding his chin, he asked me, what about if a bus runs over this lady and she dies? And he said so with a very deep Italian accent. Yes, Mr. Odera, what would happen if a bus ran over her and she died? Then I told the fellow, please don't have those thoughts or those ideas. And he said, no, just a thought. We have to think widely over some of these issues. Okay. So my client then commenced what one says, implementing the court order, but contemptuously, in the sense that he would tell the lady to come to the office, and he would have gone to the bank and withdrawn the amounts. Then it was 2,000 and something shillings. He withdrew those amounts in coins. And then when the lady comes, the lady would count the coins and put them in stacks. And once she confirms she's received them, he would sign. And even the money bag, which the coins had been transported from the bank to the office, he would refuse to give it to her. So she would put all these things in a rather large handbag. And he did that for 1 month. The second month, she came with a press. So the thing was captured in one of the newspapers, and I had to call my client and told him, being contemptuous will not really assist you. And eventually, he allocated that role to his accountant to be paying the lady. So those were one of those interesting things after the old regime. When the new regime came, it took time for the Employment and Labor Relations Court to apply the law as set out in the various pieces of legislation. They kept on reading provisions into this new legislation, which were not in the legislation. And I recall in the formative years, I did a lot of cases, first in the Employment and Labor Relations, and invariably would end up in the Court of Appeal. And the Court of Appeal would have to reconsider these cases and set out what the law is, what in law we call set up the jurisprudence. And we did this, and I must say, over a period of time, by and large, the Employment and Labor Relations Court is aligning to applying the law as provided, not as they think it ought to be. An example is a case which I did. There was a bank which was trying to restructure so as to, first of all, strengthen its capital base and to make it viable. And one of the things it had to do is to cut costs. It closed some of its branches, sold off some of its branches, and proposed to also let go some of the employees. They then sent out to employees in a general circular an invitation for those employees who would like an early retirement to apply. And as a sweetener, the bank offered them certain concessions on their loans, some golden handshake payment, and many employees applied. I mean, the thing was supposed to be those employees who were of a certain age but had not reached the age of 50. So after the employees applying, they signed off, they said they understood, the bank went ahead and paid them what was promised, and everybody went home, and we thought it was the end of the matter. And as is, sometimes when employees have left, they set up probably WhatsApp groups, or they have a forum where they meet and discuss. And in the course of their discussion, they decided that no, they were not paid enough. They should have been paid more money. They then decided to sue. And they sued my client, and I thought it was a rather straightforward case. We went for the hearing. The employees who presented themselves as witnesses, they all conceded that the bank had paid them in accordance to what was agreed, and that there's nothing more which they signed for which the bank hasn't paid. Then I asked the guys, so has the bank done something which the agreement obligated them to do and they haven't done? They said no. Then why are you in court? The guy said, because we want more money. And I was shocked when the judgment came. The court, Employment and Labor Relations Court, actually gave them more money. And the judge took the position that they should have been given more money. So it amounted to rewriting a contract between the parties. We went to the Court of Appeal, and the matter was fast-tracked because the amount which was awarded was so colossal and significant that it was important for a decision to be made, not only to set what the law is, but also, if the judge was wrong, to right that wrong. So the Court of Appeal, after arguments, agreed with me and set aside that judgment. And of course, employment matters, especially those touching on redundancies, can be very painful, because here are people who are being cut loose from employment. Many of them are people who are still within that working age. They probably have young families, many other dependents. And the choice that comes is whether the employer should maintain its entire workforce and everybody and the company collapse together, or to let go certain people so that others remain and the company continues. It's usually a very, very painful and emotional decision. And in some of the cases which I have been involved in, even as you defend the employer, you must do so in a humane manner, and to be able to do it in a way that even the affected employees recognize or appreciate that it was a necessary step that had to be taken. So employment and labor relations is not purely a matter which you look at in terms of what the contract says, what the law says and all. You must, by all means, urge what the contract says, defend what the law says, but do so in a humane manner that also the employee who is affected, even the employer who is affected, at the end of the day will say, I was heard, a decision was made, and I have to live with it.
Very interesting to hear some of your experiences. And I'm sure that if we were to continue engaging today, we would speak for the whole day. Since, 38 years of experience, you must have handled very many cases throughout your career. But as we come to a close, maybe just a few parting shots. If I were to tell you to describe your legal career in one word, what word would you use to describe?
Fulfilling.
If I were to tell you to give some words or write a letter to the young Chacha who is just starting out, what would you tell him?
Patience and consistency.
And for the viewers and the young lawyers watching you right now who are looking to grow their law career, what advice would you give them?
There are no shortcuts to this. It's a journey. And I recall, and I will share this, Dr. Robin Mogere one time told me something interesting. The choice you have in any career development is you can choose to have a steep ascent and plateau and come down just as quickly. Or the other option is to gain altitude consistently and supported by hard work, and those are the foundational bricks, and plateau at the peak of your career at a much later stage and enjoy your career at the plateau for a considerable period of time before you now start easing off the career. So what will I tell young guys? Don't be impatient. One thing you have working for you is your age and your energy. Enjoy the journey. It is certainly enjoyable if you walk it properly.
Thank you, Chacha. It has been a very good conversation that we've had, very insightful. I have personally been able to learn a lot, and I hope that our viewers will also be able to have taken something from the conversation we've had. I would like to take this opportunity to thank you, Chacha, for taking the time to sit with me today and tell me about your experience. I have learned a lot from your experience, and I would say I'm sure most of our viewers will have learned a lot from your experience as well. Until next time, we would like to take this opportunity to thank you once again for taking the time to listen to us. And bye, and yeah, see you next time.